they got there. At the time of Roe, 30 states still prohibited abortion at all stages. In the years prior to that decision, about a third of the states had liberalized their laws, but Roe abruptly ended that political process. Moving on. Justice Alito then goes on to talk about the 1992 Planned Parenthood of Southeastern Pennsylvania versus Casey case, where he says the court revisited Roe, but the members of the court split in three different ways. I'm not going to read that part to you. I will simply say that my takeaway from Casey was that some abortion restrictions can pass constitutional muster, but the fundamental tenets of Roe, the viability point, still left intact. Moving on. Justice Alito. Before us now is one such state law, meaning something that then grew out of the attempt at restricting abortion. It's the state of Mississippi asks us to uphold the constitutionality of a law that generally prohibits an abortion after the 15th week of pregnancy, several weeks before the point at which a fetus is now regarded as viable outside the womb. Okay? And this, remember now what I've been telling you, I don't think you can square Roe versus Wade with Mississippi at 15 weeks. Viability is 21, 22 weeks. It's not 15. We may never get to 15 despite medical advance. So you can't say, this is me speaking, not Alito, you can't say that Mississippi's law is constitutionally valid while leaving intact Roe versus Wade. It's one or the other. Is it 15 weeks or is it 21, 22 weeks? More from Justice Alito. This is again, still in the introduction of this 89-page opinion. He gets now to the conclusion and then goes back and justifies it. That's the way these opinions work. We hold that Roe and Casey must be overturned. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be, quote, deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. Wow. How subjective is that? So what he's saying is, all right, there are some things, this goes back to my conversation with Chemerinsky, hey, where in the 14th Amendment do I see abortion? Chemerinsky says, well, where do you see same-sex marriage? You know, that's the way that our system has developed. So what Justice Alito is saying is there are some unspecified things that we protect, some unspecified rights that we protect, but they've got to be deeply rooted in this nation's history and tradition. Now, let me just cut to the chase and tell you, he's about to explain how there's nothing deeply rooted in our history and tradition that would protect abortion. In fact, he says in the very next paragraph, the right to abortion does not fall within this category. Until the latter part of the 20th century, such a right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. And so he concludes, quote, it is time to heed the Constitution and return the issue of abortion to the people's elected representatives. There is then discussion of the factual background of this particular case, identifies the parties, summarizes what each of their thinking and legal arguments are. And then he says, we begin by considering the critical question whether the Constitution, properly understood, confers a right to obtain an abortion. You know what occurs to me? I should quickly read to you the 14th Amendment, Section 1. I hope your eyes are not glazing over. TC is my litmus test. TC, if I see you doze off, I'm jumping out of this segment.
I'm wide awake.
Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and to the state wherein they reside. That has no bearing on what we're discussing. This does. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, pay attention. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Okay? That's what we're talking about with regard to the 14th Amendment. He says Roe was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned. Again, just trying to pick out for you things that you need to know from the 89-page opinion of Justice Alito, the draft. Justice Alito then zeroes in on something that came out of the Casey opinion, which is what he calls the bold assertion that the abortion right is an aspect of the liberty protected by the Due Process Clause. As I just read to you, nor shall any state deprive any person of life, liberty, or property without due process of law. That is a fundamental predicate, basis, foundation for Roe and Casey. And now he addresses it. He says, there are rights guaranteed by the first 8 amendments. Those amendments originally applied only to the federal government, but the Supreme Court has held that the Due Process Clause of the 14th incorporates the great majority of those rights. That's really not relevant, but I need to tell you that to set this up. The second category, which is the one in question here, comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. So now he's getting to the issue that I raised with Chemerinsky, which is like, where in the Constitution do I see abortion? Well, you don't, but, there are a whole host of rights that we have recognized as having been afforded that are similarly not mentioned in the Constitution. And now Alito is going to try and distinguish why they get to stay, but abortion does not. He says, in deciding whether a right falls into either of these categories, the court has long asked whether the right is, quote, remember this, deeply rooted in our history and tradition, and whether it is essential to our nation's scheme of ordered liberty. See, I think this now is the most important part of the decision. And I'm only, like, my God, 13 pages in. What he's trying to do now is to say, hey, this only applies to abortion. And these other non-enumerated rights, they still get to stand. In fact, I hope I find it now. I found it last night. There's actually a paragraph where he said, this doesn't apply to any of those other things. He's trying to carve out an island for rights recognized that are not in the Constitution, but differentiate them from abortion. In other words, he's saying, well, abortion isn't referenced anywhere in the Constitution. It is without constitutional foundation. Therefore, it can't be supported. But those other things, they're still fine. With regard to abortion, he says, until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. Zero. Period. None, period. No state constitutional provision had recognized such a right. Until a few years before Roe was handed down, no federal or state government had recognized such a right, nor had any scholarly treatise of which we are aware. See what he's doing now? He's trying to convince that this is not a part of our tradition. Because not until, 1970 were we even having this conversation. And then he says, quote, not only was there no support for such a constitutional right until shortly before Roe, but abortion had long been a crime in every single state. Or, as Justice Alito then says, the inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. He says the respondents and their amici, those friends of theirs, have no persuasive answer to this historical evidence. What's he saying? He's saying there are things we recognize that are not in the Constitution, but they are part of our tradition. They are part of our nation's history and traditions, but abortion isn't one of them. And that's how he's seeking to distinguish other unenumerated rights from this issue. There is then very important discussion. It's hard for me to condense all 89 pages. I'm just trying to give you some of the takeaways you might not have heard with superficial conversation last night on the cable outlets about this. But what about stare decisis? What about the thing decided? What about super precedent? He goes on to say some of our most important constitutional decisions have been overruled in prior precedents. And he mentions three, not the least of which is Brown versus the Board of Education, where the court repudiated the separate but equal doctrine. So he addresses that in the decision as well, which I recommend everybody read if you're willing to invest the time. And in that vein, he says Roe 2 was egregiously wrong and deeply damaging for reasons already explained. Quote, Roe's constitutional analysis was far outside the bounds of any reasonable interpretation of the various constitutional provisions to which it vaguely pointed. Roe, he argues, was on a collision course with the Constitution from the day that it was decided, and Casey perpetuated these errors. And he continually comes back to the whole trimester viability argument, the one that I find so practical, but as I've said previously, so kind of lacking in constitutional foundation. Justice Alito says, quote, this elaborate scheme was the court's own brainchild. This is with regard to the Roe decision in 73. Neither party advocated the trimester framework, nor did either party or any amicus argue that viability should mark the point at which the scope of the abortion right and a state's regulatory authority should be substantially transformed. Not only did the scheme resemble the work of a legislature, but the court made little effort to explain how these rules could be deduced from any of the sources on which constitutional decisions are usually based. On this same issue, but further along in the opinion, Justice Alito says the viability line, which Casey termed Roe's central rule, makes no sense.